What exactly is the process to modify a divorce decree? Attorney John Haughton explains, "The only matters that can be modified post-divorce are child support, child visitation, and possession, and possibly spousal support. A divorce decree is similar to any other judgment, which becomes final 30 days after the judgment is entered. Generally, only issues related to child support, custody, and possession that are subject to modification. This is because the court has continuing jurisdiction over the children of the marriage. A suit to modify is just like any other lawsuit. The petition, referred to as a suit affecting parent-child relationship, or motion to modify, is filed with the district clerk, and then the district court clerk issues a citation, which is served on the other party. That party has 20 days, and until the next Monday at 10 a.m. to file an answer. Once the petition is filed, usually there is an early request for temporary orders, so the court will schedule a hearing for those temporary orders. In that hearing, the court will determine the custody of children while the suit is pending, temporary child support and spousal support, possession, and any other orders that are necessary to maintain the status quo and protect the parties and the children during the litigation. Once you've gotten through that stage of your case, you go through the same process you would in any other civil court case. The parties will exchange discovery requests, which consist of requests for disclosure, requests for production, requests for admission, interrogatories, and depositions. Each form of discovery is designed to elicit information related to the claims and defenses of the parties, and it is essential that you take the time to make sure the information you provide is accurate. This is often the most expensive stage of the litigation. Once discovery is complete, one or both of the litigants may file a motion for summary judgment. This is not common in family law litigation, but it is permissible and in an appropriate circumstance may be warranted. Most courts in Texas require the parties to a child custody case to participate in mediation. The parties present the case to a mediator who acts as an impartial third party to help the parties to the lawsuit settle the case without a trial. If mediation fails to settle the case, the parties continue to prepare for trial and often file pretrial motions asking the court to rule on matters which are likely to arise in trial. The trial may proceed before the judge, or the parties may elect to present the case to a jury in appropriate situations. Depending on the outcome of the case at trial, one or both parties may ask the court for a new trial. A motion for a new trial must be filed within 30 days from the date of the judgment. At the new trial, the court can consider new evidence, or the court may consider or reconsider the decision of the judge or jury to ensure the judgment is consistent with the evidence and applicable law. Finally, the parties may elect to appeal an undesirable judgment. Within 30 days of the judgment, or longer if the motion for a new trial has been presented, a party must file a notice of appeal and ask the court reporter to prepare the transcript of the trial with all pleadings and exhibits. The parties are given an opportunity to present briefs to the Court of Appeals, and the Court of Appeals may or may not set the matter for argument. The court will render a decision once it has had an opportunity to consider the record and arguments of the parties. One or both parties may appeal the decision of the Court of Appeals to the Texas Supreme Court for a final determination. The Texas Supreme Court may or may not accept the appeal for consideration. You file the petition. It is served on the other party, and that party files an answer. Then you go through the normal steps of litigation, which include discovery, dispositive motions, mediation, and then a final hearing or a trial. The court determines whether the requested modification is going to be granted, and to what extent. At Haughton Law Group, PC, our decades of legal practice means that we can analyze your case quickly and accurately. We have acquired extensive knowledge in our chosen practice areas and also knowledge of the customs of the courts, judges, and attorneys throughout North Texas. We work hard to resolve your cases fairly.